In a case that laid bare the unseemly culture of patronage on Beacon Hill, a guilty verdict today in the trial of former probation commissioner John J. O'Brien. The jury found O'Brien guilty of mail fraud, racketeering, and racketeering conspiracy. His top aide, Elizabeth Tavares, was also found guilty on those charges. A third official, William Burke, was convicted of just conspiracy but acquitted on the other charges. Outside the Moakley Courthouse, U.S. Attorney Carmen Ortiz said the verdict sends a message about public corruption.
For their own reasons, Mr. O'Brien and his colleagues implemented a rigged hiring system. This system demoralized hard-working, qualified employees, clearly preventing the department from working and operating at its optimal best. In essence, it also robbed the taxpayers of a return of the investment of their tax dollars and violated their trust and their expectations that probation would operate in a professional and proficient manner.
Meanwhile, a defense attorney for Elizabeth Tavares offered a terse assessment.
We respect the jury's decision. We disagree with it. We will be in the process of preparing post-trial motions with regard to the verdict based on our view of the evidence, and we will, at the appropriate time, if we don't prevail on those, be filing an appeal on behalf of our client, Elizabeth Tavares, who maintains her innocence.
So what do the convictions mean, and will this case prompt calls for further reforms on Beacon Hill? Joining me now is Morris Cunningham, a professor of political science at UMass Boston, an active blogger on Massachusetts politics. Also here is Jeremy Sternberg, a former federal prosecutor who now has a criminal defense practice at Holland and Knight. Welcome to both of you gentlemen.
Thank you.
So, were either of you surprised by this verdict?
I think I was surprised. I think it was a very difficult case, a very chancy case for the U.S. Attorney. The jury was out for so long that it certainly sowed doubts that they thought there was something corrupt going on here. At the end, they did make that judgment.
Jeremy?
I was not surprised that they came back guilty on some of the mail fraud verdicts. The evidence of some of the hiring decisions that were underlying those mail fraud counts was very bad conduct. Some highly unqualified people were hired over others who were clearly qualified. The racketeering and the racketeering conspiracy seemed like closer questions, and certainly toward the end of the trial, there were issues about whether the legislature actually did favors for the probation department. But with this verdict, clearly a strong victory for the government.
I think the thing that was surprising to me is that the judge over and over again reminded the jury and anyone sitting in the courtroom that patronage in and of itself is not illegal. And I think if I were sitting on that jury, I don't know if I'd be able to get that out of my mind. And I know the instructions to the jury were incredibly complicated. They came back with over 200 questions, so it wasn't like it just sank right in. But I think I would have had a hard time getting that notion out of my head.
I think they probably did. And as Jeremy says, there's some really bad conduct here, probably beyond what we think of as business as usual. Patronage will always go on. It will continue to go on in years hence. But that may have frozen the jury some, I suppose, because it's a very close call as to whether or not this is really criminal behavior in the minds of many people.
Some of the conduct that was underlying the mail fraud counts that
that's where it got really dicey. The mail fraud. I mean,
well, you had active lying on forms about.
Exactly.
What was someone's performance? How did they rate? Those were altered, and there were lies on there. And you had some just terrible candidates. You know, the drug-addled son of a judge should not be overseeing probationers who are perhaps convicted of drug crimes.
So what do you make of some of the acquittals? Burke, I mean, they were all in on this. In fact, we can speak frankly, they weren't the only ones in on it. Everybody was in on it, including House and Senate leadership. I mean, everybody knew that this is the way it worked.
Yeah, and in that respect, I don't think that this is a trial that is going to convict the acts of patronage, as a matter of fact, because it will go on. Legislators will continue to have constituents call and say, I need something. They will continue to have other legislators come to them and say, can you help me with this? I can help you with that. It's going to be very dicey how this goes forward, but to claim in any way that this will end patronage or end politics as usual, I think is just not going to happen.
I think it's a very discerning verdict. The jury acquitted on some counts, convicted on many others, and what it shows is that the jurors didn't just get into the jury room and say, okay, let's finish our job here and it's guilty across the board or not guilty across the board. They went through count by count, and even some of the questions that they asked while they were deliberating about, for example, asking for an explanation about interstate commerce as it related to the racketeering count. It shows that this is a jury that took it seriously, took its time to go through the evidence on a count by count, defendant by defendant basis. And for the prosecution, that is great. It makes the case much more bulletproof on appeal.
So the possible sentence for this is really, really tough. They're going to be sentenced on November 18th after Election Day. But any one of these counts could bring a maximum of 20 years. So they could either do concurrent, they could do consecutive, but I mean, they could each be looking at that amount of time. Am I right? I mean, Sal DeMacy got 8, which seemed harsh in some quarters, but this could be really tough.
Highly unlikely. In these federal cases, it's very rare to impose a consecutive sentence. And while the maximum sentence for each of the crimes upon which there was a conviction is, I believe, 20 years.
Yeah, 20.
The ultimate sentence is likely to be a fraction of that. It will be not strictly governed by, but it will be based on the sentencing guidelines, which
3 to 5. Or?
I would think somewhere in the 5 to 10 year range. It'll be based on factors such as loss and who was in control, and there are a variety of factors that go into the sentencing guidelines. But we'll see a sentence, I believe, far below the 20-year maximums.
It's a long time. It's a long time to be looking at. It's a truly awful thing for these families to be looking at, for any of these defendants to be looking at. It is truly awesome.
Well, you've done a lot of writing, not only on this, but on previous speakers and all the travails we've had in leadership in the House and the Senate. I mean, is this going to stain Robert DeLeo, do you think? I mean, is he an unindicted co-conspirator in a way? I mean, his name came up over and over. I mean, no one can deny that they were part of it. I mean, that's how it worked. Is it? Hey, I got somebody that I want to place over in probation.
I am very troubled by the tag of unindicted co-conspirator in this case.
That was my tag. That's all right.
I truly am. No, he has been tagged by the U.S. Attorney as an unindicted co-conspirator. And there's a wonderful exhibit over the MFA. The Magna Carta is here. 800 years old. And right there is where we begin to have due process and the notion that government can't come down on us without making its case. And this isn't making its case. This is indicting his reputation. And I am very, very troubled by that. And I am not somebody who buys into the three speakers story. I think Flaherty and excuse me, now I'm drawing a blank. Flaherty and Finneran were ill-treated by the U.S. Attorney's Office in those cases. And so I think it is damaging, but I don't think it's justified.
What do you think?
Well, I think the concept of unindicted co-conspirators goes back many years. There's nothing wrong with having unindicted co-conspirators in indictments that charge a conspiracy. That's a very common element of those indictments. What's unusual here is that often an unindicted co-conspirator is either someone who cooperates and is immunized and testifies at the trial, or someone who's pled guilty and also testifies at the trial. It's a bit unusual to have an unindicted co-conspirator who has absolutely no role whatsoever in the case, other than just having his name floated about.
By the way, these people will probably go to jail, even although they'll say, can we hold out until after the appeal, but that likely doesn't happen, does it?
I don't do.
No.
It often can, particularly in white-collar cases. So they may have their sentences, their need to report to prison stayed until the appeal is decided.
All right. Thanks very much. Will Cunningham, always Jeremy Stenner. Thank you so much.